The following program frequently combines snark with clever innuendo. We really hope that you aren't offended. Really. We will even give you a safe space. There. Isn't that better? I'm back. Good evening, everybody. Welcome to the following program. I'm your host, Joe Neerman, a.k.a. Good Lawgic. Hope that your last couple of days during my absence, it's been a time for you to reflect. Maybe you shut down the internet also. Maybe you took a cue from the host, not the leader, but the host of the following. I said, you know what? A day away from the internet or so, seems like a good idea. I spent 50 hours away from the internet, and I came back totally refreshed, feeling like I have absolutely no idea what's going on with the world, and that's a good thing. And I came back to find that I was like, oh my God, I really forgot how insane our world is. Oh my God, it's really insane. I don't know how you guys just put up with this all the time, and never getting a break from it. You need to decompress, I'm telling you. I got to spend the holidays with Lady Lawgic and the one who everyone refers to as Baby Lawgic, which is my youngest, my 10-year-old. It's really not a baby, but yeah. So that was the rest of my family was four corners of the earth. We still had a wonderful holiday. Those of you who are curious. And I come back and I'm like, I just overwhelmed by just the insanity that I saw. So I want to thank those of you who helped call to my attention various levels of insanity that have been going on over the last couple of days. And one of the insane things that happened, a couple of them that happened the day after I last streamed and before I even went on holiday, are ones that are going to really focus on. That's Judge Glanville's order, as well as the subsequent issues that have arisen. Specifically, I'm going to be going through a motion for Judge Glanville to recuse himself and talk about the strength of that motion, whether or not it seems likely that request will be granted. And I'm going to also be talking about Hunter's conviction and the insane levels of cope. Oh my gosh, so much cope from the left about that conviction. Wow, so much cope. Yes, that's gonna be fun. And I also plan on really assessing the bankruptcy, the petition to the bankruptcy court in the Alex Jones case, where they're looking to have Alex Jones turn over his social media accounts, and the viability of that request, logic behind it. And I'm going to leave that issue. I'm really going to just try and break down the legal issues and logic behind it as to whether there is logic or whether it's barren of any logic. Definitely seems aggressive. Judgment execution, if it's going to be successful, frequently needs to be aggressive. I know that from firsthand. So I'm going to talk to you. I'm going to analyze with you that application, and specifically their attempts to get him to force him to sell his social media accounts, and what that would actually look like. Anyhow, but first and foremost, before I go anywhere, I need to start off with the king and queen of recruitment. First, the queen who beat me. You beat me, Bella. You beat me. I'm not going to kid it. I'm not going to kid you. You totally, completely beat me because you actually got this up here before I had a chance to actually catch who it is that you gifted. I have no idea. I didn't mean to do that. I meant to bring the screen in here so you all hear the horn so richly deserved by Bella Stella for gifting 10 Good Lawgic memberships, as well as the king of recruitment. As always, Master Phillips popping in as well with another 10. So Bella beat me. Bella beat me, but
Really?
this wasn't. I am able to catch the 10 courtesy of Master Phillips. Let's check out who we brought in. Let's see who we brought in here. Why is this not? Definitely have it. I know I have it. Definitely got it here. Where are you? Where are you? Come on. Maddie Adams. 10 people who were brought in. Like I said, if you were gifted by Bella Stella, please, I hope you make sure that you extend your gratitude to her. 10 people brought in courtesy of Master Phillips. It are Maddie Adams, Andy Gorski, Raw B. Mill, Kiska Hamblin, Ebal Nunya, I am Dave. Loving 2 limes. Look at that. 2 limes. Usually hanging out on Rumble. Coming to visit, stopping by YouTube. Stopping by, paying some dividends. Arnold Newton, Margot Eichenlaub, and Raven. All of them gifted memberships courtesy of. I'm talking into the mic. I got Audio Joe in my head with his changing his name to talking to the mic. Unbelievable. Talking into the mic. What do I have to have like this thing like shoved down my throat? So those of you who are gifted courtesy of Bella Stella and or Master Phillips, and I'm even going to include in there the very courteous and kind Lily Smith saying, "Hi Joe, missed you. Hope you don't have to go in front of that judge soon." That's not likely. He's a criminal court judge, so I'd be very, very upset if I ever end up in front of him. Oh my God, I'd have much bigger problems than the fact that I'm in front of Judge Merchan if I end up having to go in front of him. So all of you who are gifted memberships to the following. So I just want to, in case you're new to the following is not at all a cult type of cult. You should not think that you're in a cult. You should never consider that you're in a cult. It's not even anything remotely culty, cult-like, cultish. Nothing related to a cult. I'm not the leader of the following. The following is just a group of people who are interested in personal growth. They attain that through stronger community, unity, and leadership training. See, it breaks down very simply. You can remember via an acronym like CULT, community, unity, leadership. That's all about personal growth, but it's not. And a lot of people hear the name following. They get all crazy, like, oh, I'm part of some sort of like cult. Oh, it's not at all a cult type of cult. There's no spaceships, no self-harm, no harming others, no stabbing yourself with the jabby jab, no tracksuits that are mandatory. I mean, they're optional. They're not at all mandatory. Not at all. This is like a key distinction. I can't stress this enough. It's not at all mandatory. Not at all. Not at all. No dancing around bonfires while shucking off clothing to the beat of a tom-tom in the middle of a forest. No throwing virgins into volcanoes. There's absolutely no squirrel mutilations. No squirrel mutations, whatever Adrian tells you. And that's not just for Adrian because she's like this whole protector of the squirrels. No, we just don't have squirrel mutilations, no goat sacrifices. It's not at all a cult type of cult. And I'm not the leader of the following. The title belongs to others who are far more impressive, have far more impressive resumes than I do. Jenny L jumping in here with a very courteous hello and glad you're back. Don't forget to like and subscribe, good people. Yes, where is our subscriber count? What's been going on with that? I should probably check up on what that subscriber count is looking like right now. What is that subscriber count? Oh, look at that. Look at that. Should we share that? We can share that. That's not a bad number. That's not a bad number. Look at that. 98,726 is where our current count is at. 98,726. Just a little under 1,300 away from that coveted objective of 100,000 that some people covet. I covet 1 million. So I look at it as if I'm only 901,000. 900. Wait. 900. Yeah, I'm 901,300 away from my goal of where I'm looking to get to. But we're getting there. We're working there. And speaking of new members, welcome to the following, Russell. Welcome, Russell. Nathan C., member for 19 months. Sup, my diggers? Less than 1,300 from 100K. Tell your friends, family, subscribe. Complimentary tracksuit dry cleaning for every 100 subs. No, that's not really true, because there are people like Master Phillips and Bella Stella brought in way more than 100 subs, and yeah, there's no that's not my statement right there. 17-page paper of published quality or 20 days. I don't know what that means. I don't know what you're trying to hit me with over there. Anyway, okay. Let's jump right in and talk about Judge Glanville. Judge Ural Glanville. By the way, I happen to love his first name. That's pretty cool, first name. I'm not going to kid you. Very little else about him is very impressive, but his first name is certainly impressive. But let's look at his order that he brought up on June 11th. I'm going to make this a little bigger so y'all can see it. All right, here we go. This is what he wrote. This is what this guy wrote. So you all remember we covered on wait, I'm getting confused. On Monday night. So we talked about that insane day in court, and I had Steve Gosney on here, that was like a killer show. I was very proud of the work product that we did there, because I felt like we brought like a lot of facts and logic and perspectives that you're probably not going to see in many other places. So that was on June 10th. On June 11th, this is an order to show cause that it's rare to have a judge file an order to show cause. That almost never happens. It's a very, very rare thing. Very rare thing. I can't stress that enough. Just think of like the rarest thing that you've ever thought of. And then there's this, which is like somehow rarer still. Very, very rare for judges to file their own order to show cause. I can't recall ever seeing it. Doesn't mean they sometimes will bring motions sua sponte. They'll bring application. They'll make decisions sua sponte, which means on the spot. It's a Latin term. I think it stands for on the spot. But it's of their own volition, and they basically will come out with something. That's one thing. A formal order to show cause like this, highly unusual. Highly unusual. And what he says here, so an order to show cause basically is an order compelling someone, and this is a vehicle that we have in civil court here in New York. It's not a vehicle that's available in all 50 states. It's a form of motion. It's very weird for a judge to bring a motion in general in case that he's presiding over. That's part of what makes this so weird. But it's a type of motion which usually is compelling people. It's looking to compel people to do something. And it's the type of thing you would attach here in New York if you're filing for a TRO. Right? When you're looking for injunctive reliefs, you would bring that motion not via notice of motion, but by order to show cause, because an order to show cause is a way of having a more expedited motion instead of having the standard turnaround times, which will be 21 days or something like that, or 28 days, depending on the nature of it. It's a much faster turnaround time. And what you do when you're filing it with a court, not when the judge is doing it himself, what you would do is you would create this form which says order to show cause, and you would ask the court to put in the time for when everything is returnable and spell out the nature of the relief that you're seeking. And like I said, this is not something that's available in all 50 states. I assumed it was until I heard Rob Gouveia when he heard me referring to an order to show cause, not knowing what I'm talking about. And I don't think that's due to any lack of his knowledge of litigation. I think he's probably very experienced when it comes to litigation. It's just not something they have in Arizona where he practices. But we do have it in New York, and apparently they have a similar thing in Georgia. Judge Glanville bringing his own order to show cause is very weird, because normally motions are filed by litigants, not by a judge himself. Now, an order to show cause will frequently have an order in it that's signed by the judge. And the nature of the order can be a TRO being signed. And another element to the order will be when it's returnable. What day are we all coming back to court to further address the matters that are being raised? So, and sometimes you'll have an order to show cause when you're looking to have someone held in contempt, but that would, again, be a litigant. It's not really a judge who does that. A litigant might say, I want the other side to be held in contempt. And what you do basically is they sign, when the judge signs it, it makes it compulsory on the other side to come in. and to appear at a certain time. If they fail to appear, then they could be held in contempt or other various penalties they may suffer, like the grant of your requested relief. I want something to happen. If you don't show up, you need to come in and show cause, explain to the judge why I should not get the relief that I'm seeking. That's why we call it an order to show cause. You're ordered to come in here and show the nature of your cause opposing my relief that I'm seeking. So that's the way an order to show cause normally works. And there almost is baked into it an assumption that the relief is going to be granted if you don't show cause why it shouldn't be granted. It does not necessarily follow that it will, because once you're signing an order to show cause, it could be that a judge will look through your papers more thoroughly. Let's assume someone doesn't show up. There's an order compelling them. You must appear on date X at this time, and let's say someone doesn't show up. Well, more often than not, your relief is going to be granted. More often than not, there won't be like a contempt, how dare you not show up? It'll be a matter of, well, you didn't show up to oppose the relief, therefore the relief is being signed off by the judge, and now you have no opportunity to fight against it. But sometimes, specifically with a contempt order, we really just want to haul this guy's butt in front of the judge. So that is a common way that you can do that, is via order to show cause. Now, the court, the way he words this is, the court having been presented with an issue of contempt for determination. Okay. I'm not sure who's presenting that. They presented it themselves. And the issue of contempt is this own issue that the judge came up with a day earlier, which this is a weird opening already. All individuals that were present for the ex parte conversation that took place in the court's chambers on the morning of June 10, 2024, to include the witness, Mr. Kenneth Copeland, his attorney, Miss Kayla Bumpus. And if you recall, by the way, if you watched the stream where I was going through his whole questioning of the attorney, Mr. Brian Steele, the judge made reference to how there was some woman that he seemed to think was culpable for sharing this information with Brian Steele. And to my mind, he's probably referring to Copeland's attorney, Kayla Bumpus, because it's very unlikely it's anyone else on this list. So his attorney, Ms. Kayla Bumpus, and all representatives of the state and court security personnel that were in attendance are hereby ordered to show cause before the Honorable Uriel Glanville on 25th day of June 2024 at 9 a.m. in Court 1C, and giving the location. They always have to give the location to make it clear where the parties are expected to show up. And I just want to point out the 25th day of June happens to be my birthday. So happy birthday to me, because I will be streaming this. I'll tell you that. I definitely will be streaming this. Oh, yeah. Oh, yeah. Happy birthday to me. Because what a cluster fart this is going to be. And I'm gonna be here for every moment of it. I'm gonna be here with bells on. I'm very excited to be streaming this sucker. So on the 25th day of June at 9 a.m., what are they there to establish? Why one or more of them should not be held in contempt for disclosing information from the ex parte conversation to members of the defense counsel. So you're going to have to come in here on June 25th and explain to me why I should not hold you in contempt for sharing information from that ex parte meeting with adverse counsel. Fascinating. It's just fascinating. When I retweeted this on Tuesday, I said, this is the equivalent. We're basically watching the Mad King here, just screaming, burn them all. I'm going to throw you all in jail. If I can't figure out who the leak is, I'm throwing you all in jail. What the heck is going on here? What the heck is going on? This is the devolution of a man. He is sinking into his own paranoia. He is freaking out. Now I have to know how he got this information. I'll throw you all in jail. I'll throw the whole lot of you in jail. I mean, the implication is that it's Kenneth Copeland and Caleb Bumpus who are at risk of being thrown in jail. And you have to ask yourself, is that something you can be held in contempt for sharing that information? I mean, normally an ex parte meeting is for the benefit of certain parties who are looking to have an ex parte meeting. Where it is that this now becomes a proprietary information, the way the court implied it was on Monday, the origin of that'd be part of my defense. If I was Caleb Bumpus or Kenneth Copeland, I'd be like, why are we not allowed to tell anyone I want? I can go home and tell whoever I want. If I want to tell defense counsel, I can tell defense counsel. So that when you have to show cause, you have to show legal justification as to why you did what I did. The answer to that is, I don't know, First Amendment. maybe I got freedom of speech, unless there's a court order which restricted them from speaking, which is possible that there was a court order that said, hey, you can't talk about it. But then you sort of have to ask yourself, what's the legal justification for the judge issuing such a court order? That seems kind of weird. Right? Like, well, why are you signing a court order saying that everything here is private? That's kind of strange. That's kind of weird. It's further order. The failure of any individuals who were present for the June 10, 2024 ex parte conversation will cause, I guess, to appear. He left out the words. Failure of any individuals who were present for the June ex parte conversation, the failure to appear is what he's by any of the individuals. Yeah, I think he dropped the ball in his wording here. Will cause the court to direct the Fulton County Sheriff's Office to take them into custody and bring them to the bar of this court. So ordered this 11th day of June, 2024. This is insanity. This is insanity. It's like, he's a witch, he's a witch, he's a witch. I'm not a witch. That's what this is. It's like, who are we going to blame now? This is literally, I mean, whoever it is the witch, right? Is the witch. I'm wondering if he's going to have like carrots attached to like an elastic band that he can just sort of shove on Caleb Bumpus's nose. Get out like a scale, put a duck on one side, have her on the other side, see which of them weighs more. I don't know what's going to happen here. This is really, really wild. But it seems as if you ask me, Caleb Bumpus is the one who's in his sights here. But in theory, everyone is supposed to be there. And anyone who was there must come back on June 25th. And if you don't, what's going to happen? It's going to cause the court to direct the Fulton County Sheriff's Office, take them into custody, and bring them to the bar of this court. You're going to be brought in here in chains. In chains if you don't come in here voluntarily. Wow. Will he air it? That's really the question. Is it going to be another in-conference thing? Like, I need to know, because we don't even know. I'm happy to stream it if it's being shared live. I'm just wondering, like, how stupid would that be to actually conduct this in public? Like, how is that? If the whole point is, this is such a weird situation. How he made this bed for himself. So stupid. This is just, he's caving to his own paranoia. That's all I can say about it. He's literally caving to his own paranoia. This is a man who, I don't know, a week ago, he was like a totally fine, normal, respected, upstanding judge. And in one day just became completely unraveled. He seems unhinged here. That's my personal opinion. He seems completely unhinged. So, yeah. What is the cult count? Subscribe, you peasants. The judge in the case is signed. We're going to look at the motion for him to recuse himself as well. We're going to go to that very shortly. The judge in the case is signed a 17-page paper to one of the defense lawyers. Oh, that's what this is? 17-page, or published quality, or 20 days. The judge in the case assigned a 17-page paper to one of the defense lawyers because he was late. 17 pages and has to submit to Law Journal for publication. Wow. What the heck does it? That's such a random number also. Appreciate all you do. I listen to all your lawyers. Learn and appreciate you. I've been telling other truckers about you. Thank you so much. Truckers are the backbone of our country. So I appreciate all you do as well. Thank you, brother. Comment for defendant failing to comply with bond condition. Yeah, so that's when you have an order show cause to have him held in contempt. Precisely. Joe, are you saying for a judge to issue it? I don't know. See, I never deal with criminal court. To me, this is weird. To me, this is really... I've never seen a civil court, but I don't know much from criminal court. So if you're telling me that the defendant fails to comply with it, yeah, it would be common for him to issue. There wouldn't be a whole motion about it. He would just issue he would issue an order for the Fulton County Sheriff to take him into custody. That I agree with you about. It's the order show cause that's weird. Joe, this is Mrs. Entry Required. Mr. Entry Required, I want to send you something in the mail for your 100K. Where's your P.O. Box info? We both love you, Joe. Thank you so much. I don't have a P.O. Box. I used to have one. I don't have one anymore. But I was actually thinking about reestablishing it because someone else also wanted me to get something. So I'm probably going to reestablish it. Thank you. Thank you very, very much. You're very generous. Thank you. Wrap this. Ain't no party like ex parte, because an I don't know how this goes. Because an ex parte was my best. Darkborn, drop him to 20. Joe, would the person who told Mr. Steele about the secret ex parte or whatever you call it meeting be considered a whistleblower and for whistleblower protections from repercussions from Judge Glanville? I don't see why. See, whistleblowers have to go through a specific procedure. It's not like telling the adversary about it is following that procedure. Someone else mentioned this on Monday when I had this, and I was like, there's a whole special procedure for being a whistleblower, not that you just go and tell whoever you think is most efficient to tell. See what I'm saying? So I don't think that normal whistleblower statutes would be of service to anyone who ran to Brian Steele and told him this stuff. That's my personal take. Get Joe to 100K tonight. I'm buying massive memberships, peeps. Oh, God bless you. God bless you, Human. God bless you, Human. Thank you so much. All right. So that was his order. Let's see where the Return of the Jedi here. The Return of the Jedi. This is not what I wanted. I'm looking to take out the Emperor. Looking to take out the Emperor here. Check this out. Here's a motion for Judge Glanville to be recused. Let's see what we got here. Let's break this down here. How long is this motion? Because this looks really freaking long when I'm looking at it. How many pages is this? Oh, it's only 15 pages. All right. We're going to do this really fast. All right. In fact, I'm going to even do this a little differently. Let's do this a little different. I'm just going to open this in my... Let's save this. Save as... that's not working. I'm going to download this. I want to download you. Yep. There it is. Got it. All right. I have in PDF form. I can have fun with it now. I can draw on it. Everyone loves when I draw on this stuff. Draw. All right. Defendant, Mr. Diamante Kendrick, buying through his undersigned counsel without waiving any other rights to which he's entitled, files this motion to recuse Chief Judge Uriel Glanville from continuing to preside over the present case and request that the present trial be temporarily halted. Put this sucker on hold until the present motion is heard by another judge of the Superior Court consistent with the uniform rules of the Superior Court. It is vital to the function of courts. Public believe in the absolute integrity We need integrity and we need impartiality from our judges. And judicial recusal serves as a linchpin for the underlying proposition. The court should be fair and impartial. The present case involves a 65-count RICO indictment against 28 individuals. Jury selection in the case began in January 2023. January 2023, a year and a half is when jury selection? With the jury trial beginning in November 2023. Given that the state has presented less than half of its current witness list, which the state has announced could be increased based on circumstances, the trial should last well into 2025. 6 defendants presently on counsel. I'm going to make this a little wider here. Let's make this thicker. 6 defendants presently on trial include Mr. Kendrick have been denied bond and incarcerated for over 2 years. Let's understand this. They haven't been given bond and they've been incarcerated, been in prison for 2 years while we're saying they're innocent until proven guilty. Crazy. The central figure, perhaps the central figure in the state, is Kenneth Copeland. That's the guy who was on the stand. On Friday, June 7th, Kenneth Copeland was sworn in. Despite being warned by Chief Judge Uriel Glanville that incarceration may be the result of refusing to testify after being granted immunity, Copeland still refused to testify on that day. He said, I'm not doing it. I don't care. Throw me in jail. I'm not testifying. Copeland was ordered incarcerated by Chief Judge Glanville on that date. I see. Now we're understanding a lot more about this. And Chief Judge Glanville instructed Copeland and all parties that Copeland would be returned to court on Monday, June 10th at 8:30 a.m. We're going to see that this time is important, where Copeland would announce whether he was prepared to testify. Apparently, they realized he wasn't going to. On Monday, June 10th, all defense counsel were present in the Fulton County Courthouse at or around 8:30 a.m. So we're all here. We were admitted entrance in the courtroom, seated by 9 a.m. Defense counsel waited and waited and waited. And between 11 a.m. and 11:30 a.m., Glanville took the bench and announced that Copeland was prepared to testify. What the hell happened in that room? That's what we all want to know. All of a sudden, we're waiting for 2-3 hours. Now he's ready to testify? Attorney Steele, counsel for defendant Mr. Williams, inquired with this court as to the delay, what had occurred prior to Chief Judge Glanville taking the bench. His inquiry was not accepted. Not accepted well at all. Unknown to any member of defense counsel during the waiting period in the morning, upon information belief, an ex parte meeting was held in Chief Judge Uriel Glanville's chambers on June 10, 2024. Among Chief Judge Uriel Glanville, ADA Love, ADA Hilton, other members of the Fulton County District Attorney's Office. We don't know who they are, but other people were there as well. Maybe one of them blabbed. Deputies, sworn witness Ken Copeland, and Copeland's attorney. No member of defense counsel was present at the ex parte meeting. None of us were there, despite the subject matter of the meeting being a critical phase of the trial. It obviously is. We can better appreciate what a critical phase of the trial when we consider that he's arguably the key witness. He now, understand that he refused to testify, spends 3 hours in chambers there, and all of a sudden now he is testifying. What the hell did they say to him to get him to change his mind? Maybe there was undue coercion, which is relevant to their defense of their respective clients. So to say that's not a critical element to the trial is preposterous. Upon information and belief, neither Chief Judge Glanville nor any members of the court staff nor the Fulton County DA office made any member of defense counsel aware of the ex parte meeting, either before the meeting was held, during the ex parte meeting, or after. Even after the ex parte meeting, no one told us anything. That's very weird. It is very weird. Normally, when there's an ex parte meeting, even if it's justified, the court will explain to the other parties that there was an ex parte meeting. He's supposed to come to them. And instead, he's complaining that someone told him that it happened. That's so backward. We can't begin to explain that to you, how backward that is. He should have come to defense counsel and said, we had this meeting. And here's why I had, then give some sort of justification as to why it had to be ex parte. But to be outraged that the meeting was discussed and without him even coming to defense and telling them what happened, that's crazy. Copeland briefly testified prior to a lunch recess, and we saw some of his testimony, which honestly was classic. It was great. He was so funny. One or more members of defense counsel were later made aware of the ex parte meeting with sworn witness Copeland and made aware of at least some of the content and subject matter of the ex parte meeting. Upon information, believed the following events occurred at the ex parte meeting and with sworn witness Copeland in chambers. What did they learn? What do we know? What happened? Okay, so Copeland announced he would invoke his Fifth Amendment rights and not testify. Now, if they've granted him immunity, he doesn't have Fifth Amendment rights. From what I understand, that vitiates his ability to claim Fifth Amendment rights. And I think that as we understood, he was granted that immunity, and that's why the judge is like, I'm not standing behind your Fifth Amendment rights. But upon information, believed Copeland stated that he would sit in jail for 2 years. Sit in jail for 2 years rather than testify. That's what he said. I'll stay. Upon information, believed Chief Judge Glanville informed Copeland that Chief Judge Glanville could keep sworn witness Copeland incarcerated until additional defendants were tried, not just the 6 defendants currently on trial. Glanville threatened Copeland that he can keep him in jail while additional people are being tried? Wow. That's my wow face. Wow. Upon information, I need emojis. Where's my emojis? They don't give me emojis here? No. I don't got no emojis. No emojis for Joey. Well, anyway. Upon information belief, Love or Hilton informed Copeland that there were over a dozen defendants left at trial, basically saying, we're going to leave you in jail for the rest of your life if you don't testify. That's essentially what they're telling him. This is crazy. Upon information belief, the above coercive actions by Chief Judge Glanville in conjunction with one or more attorneys from the Fulton County DA's office, sworn witness Copeland stated at the ex parte meeting that he would testify. So they basically said, we're going to throw you in jail with no deadline as to when it's going to end, which that sounds ridiculous. That sounds like completely a violation of his fundamental civil liberties. I'm not even going to tell you how long he'll be in prison for. And that the judge and DA were both working in cahoots to make him feel as if he's going to be there for the rest of his life. Upon information, we're going to throw you in a hole and you're never going to get out of it unless you testify. That's essentially what they did. Upon information belief, Glanville also presented sworn witness Copeland with a printout of the perjury statute and the false statement statute of the state of Georgia during the ex parte meeting. Okay. When they say upon information belief, by the way, that just means this is what we've been led to conclude. So what are the facts we've been led to conclude? That Copeland stated to ADA Hilton that if called to testify, he would simply lie on the stand, which makes you question what the heck is the point to bringing him? To get him to lie on the stand? Upon information belief in response to Copeland's statement that he would lie, Hilton stated that she would not prosecute sworn witness Copeland if he were to lie on the stand. What the heck is happening? Go ahead. Go ahead. Lie, Kenny. Lie, Kenny. I'm not going to prosecute you if you lie. What? Are you begging him to lie? Upon information belief, Copeland also stated to Hilton that he would testify that he killed Donovan Thomas Jr., which I think that's what one of them were charged. I'll say I killed him. Upon information belief, in response to sworn witness Copeland stating to Hilton that he would testify that he killed Thomas Jr., ADA Hilton told Clinton that she would prosecute him for perjury if he testified that he killed Thomas. Maybe he did. How do we know he didn't? If you claim that you killed Thomas, I will throw you in jail for perjury. During court of the afternoon of June 10, 2024, when one or more of the above allegations were presented to the court by Attorney Steele, Glanville denied that one or more events above related to him were accurate. See, I don't know where that is. They're citing it at 21. What is this? Sources from the transcript? Did I miss that? It must be from the transcript. This is like their source. Whenever you see these, they're saying we're citing the same source in paragraph 20. It must be from the transcript. The judge must cease to act and make an immediate determination. When a trial judge is presented with a recusal motion and accompanying affidavit, the judge must temporarily cease to act on the merits and determine immediately whether the motion is timely, whether the affidavit is legally sufficient, and whether the affidavit sets forth facts that, if proved, would warrant the assigned judge recusal from the case. So let's explain to you how it is timely. Present motion is being filed and presented to the court in a timely manner. Under the Uniform Superior Court, Rule 25 governs motions for recusal. Motions to recuse, along with accompanying affidavits, are required to be submitted to the presiding judge not later than 5 days after the affiant learns of the alleged grounds of disqualification. And all this happened earlier this week. Happened just 2 days ago. Such submission shall be submitted not later than 10 days prior to the hearing or trial, which is the subject of recusal, unless good cause shown for the failure to meet the time requirements. These events all happened after the trial started, which is why we couldn't do it earlier. Given the most recent incident demanding recusal just occurred on June 10th, 2-day period elapsing from the incident requiring recusal for the filing the present motion is good cause. Sounds good to me. This all sounds good so far. So good. Present motion includes sufficient affidavit demonstrating the need for recusal. An accompanying affidavit by Douglas Weinstein, from the Weinstein Affidavit, with evidence for recusal. Is that what it was? That was the id? That was probably what it is. Not this list. It was probably coming from Weinstein's affidavit. An accompanying affidavit from Douglas Weinstein with evidence for recusal has been filed and is now presented, which fully asserts facts upon which this motion is founded as required by USCR 25.1. Let's take a look at his affidavit, because it shows that it clearly states that facts and reasons for the belief that bias or prejudice exist. The Weinstein affidavit is specific with respect to time, place, persons, and circumstances which demonstrate bias in favor of the state that prevents impartiality. In the present case, as required by USCR 25.2. The particulars of the Weinstein affidavit are provided above and not need to be presented again here in detail, but lays out alleged actions of Chief Judge Glanville in conjunction with the state with respect to sworn witness Copeland that took place in the chambers of Chief Judge Glanville on June 10, 2024. These are very serious allegations. These are allegations that extend well beyond his ability to handle this case. Because this just seems, it has such an odor of corruption. Not mendacity, but it's an odor of corruption, which is on disturbing levels. The facts alleged in the Weinstein affidavit must be assumed to be true when deciding whether recusal would be warranted. That's interesting. Why is that? The details learned by Weinstein upon information and belief detail the holding of an improper ex parte hearing conducted with the witness, which violated constitutional statutory rights of Kendrick, that's their client, including the right to due process and a fair trial. Ex parte hearing with sworn witnesses Copeland was in violation of at least Section 2.9 of the Georgia Code of Judicial Conduct. Where does that say? Assuring fair hearings and averting ex parte communication provides that judges shall accord to every person who has a legal interest in proceeding or that person's lawyer the right to be heard according to law. And then when you're having an ex parte communication, that's for scheduling or administrative purposes or emergencies that do not deal with substantive matters. The judge, provided that the judge believes that no party will gain a procedural, substantive, or tactical advantage, which that's ridiculous when you have the right to twist his arm and say, we're not gonna prosecute you for perjury. And the judge makes provision promptly to notify all other parties of the substance of the ex parte communication. That's what he had to do. Instead of doing that, he did just the opposite. He's trying to throw in jail anyone who shared this information with the other parties. It's insane. It's insane. He's obligated to tell them, and instead he wants to punish anyone who did tell them. Unbelievable. I can't put it more succinctly than that. This is what's so insane. The judge himself had a duty to tell defense counsel about the substance of the ex parte communication. And instead, he's trying to throw in prison anyone who shared that information with defense counsel. Absolutely mind-blowing what the judge even thinks he's doing here. I can't even fathom how this is going to be granted any sort of blessing from an appellate court. It's mind-blowing. And yeah, he must be recused. He has to be recused. Unbelievable. So, the ex parte hearing with the sworn witness was in violation of at least Section 2.9, which assures every person, including persons such as Mr. Kendrick, of a fair hearing. Ex parte communications are presumed to have been in error, citing City of Pendergrass. Rule 211 in the revised Georgia Code of Judicial Conduct says generally that judges shall disqualify themselves in any proceeding in which their impartiality might reasonably be questioned. Which, how the hell can you say it's not reasonably questioned? Followed by a non-exclusive list of specific situations in which recusal is required. The standard is an objective one. Facts must be considered from the perspective of a reasonable person rather than from the perception of interested parties. We don't care what the DA thinks. We don't care what the judge thinks. It's got to be from a reasonable person perspective, or from the subjective perspective of the judge whose continued presence in the case is at issue. Furthermore, Glanville should not have coerced sworn witness Copeland to testify. Trial judge should not attempt to intimidate a witness to testify on behalf of the state, either in or out of the presence of the jury. Doesn't matter whether the jury's there. You can't push him to testify. As the Georgia Supreme Court wrote, we need not decide whether such bias and impartiality actually existed because judges are ethically bound to disqualify themselves whenever the impartiality might reasonably be questioned, including instances where the judge's behavior could indicate that he or she has a personal bias or prejudice concerning the party or a party's lawyer. Defendants were not provided notice of the hearing, either before, during, or after. And regardless, defendants should have been afforded an opportunity to attend any hearing where a sworn witness in a critical stage trial is being coerced to testify. Only logical conclusion to be drawn by the willful exclusion of all defense counsel from the meeting among Chief Judge Glanville, State, and sworn witness Copeland was to harass and intimidate him into testifying. Given the facts as alleged must be assumed to be true, the Weinstein affidavit is sufficient and that recusal would be authorized under the alleged facts. Another judge should be assigned to hear this motion to recuse. We don't even want you deciding this motion. You have to bring in someone else to decide this motion. And frankly, I can't see how another judge looking at this is gonna allow Glanville to stay here. I think Glanville's done. At least certainly with respect to this trial. I think he's out. Whether Kendrick respectfully submits that the present motion meets all requirements of USCR 25.1.2 or 3, this motion should be assigned to another judge for consideration. Don't try listening to this yourself and saying, I think I'm good. In the alternative, should this court deny the request of relief to this motion to recuse Kendrick, requests the court make specific factual findings. Don't just say I deny. I want you to explain. We need you to explain your basis for denial with fact findings and submit that Chief Judge Glanville should voluntarily recuse himself. We shouldn't even have to bring this motion. He should have brought himself out of it. Should the court take neither of the above actions, Kendrick moves his court for a mistrial due to the ongoing bias of the court as evidenced in the Weinstein affidavit and on the basis that Kendrick is not receiving a fair trial as his constitutional right of due process under the Sixth Amendment. Should all the above requests of relief be denied, Kendrick requests a certificate of immediate review, which I believe is what in Georgia they do if there's a question as to what the hell is happening. Get the appellate court in there immediately. Respectfully submitted, Douglas S. Weinstein, the Georgia Bar, etc. And this is what you do, is you sort of want to give him an opportunity to do the right thing and step down. You follow this motion. Here's the affidavit they referenced. So that was filed by Weinstein. He's referencing his own affidavit. So this is basically his affirmation in support, his motion. And here's the factual elements that he's raising in here. So the factual elements that he raises are that Copeland had been held in civil contempt of court on June 7th because he refused to testify. Then Glanville instructed the witness and all parties that Copeland would be jailed and returned to court on June 10th, where he would announce whether he was prepared to testify. And his belief that defense counsel were all present in the courthouse at 8:30 a.m. on June 10th. And defense was all there by 9 o'clock. You got an ex parte meeting in his chambers. And you got these two DAs there. You got Love and Hilton, who are hanging out with Glanville. And they got Copeland in there. That didn't work out well. Along with Copeland's attorney. No member of defense, and there's no member of defense. That's what's so horrifying about this. And not only that, we were never made aware of it. Then they finally come out at 11 o'clock, all sitting around here for a couple of hours playing Yahtzee with each other. Yahtzee. At that time, Attorney Steele, when they come out, Steele, counsel for Ms. Williams, inquire with the court, what happened? What's the deal? What's been going on? Let us know. And Copeland comes out and testifies prior to lunch, does a little bit of testimony, which was kind of comical, where they asked him to identify various defendants, and he's like, think it's that guy? Maybe that guy? Upon information, I believe the ex parte meeting, Copeland announced that he would invoke his Fifth Amendment rights, even though the judge told him he can't do that because they weren't prosecuting him and they were giving him immunity. But he still said, I don't care. I'm still invoking it. And he said he would sit in jail for 2 years rather than testify. They got real details about this meeting. Where they get this from? That's what the judge is so freaked out about. It's got to be from Copeland, right? I mean, it's got to be from Copeland. Maybe his attorney. It's got to be one of them. The judge wants to know who. It's unlikely it's the DA. But who knows? Maybe it was a bailiff who was in there. You got the ex parte meeting. Glanville could keep Copeland incarcerated until additional defendants were tried, not just the 6 who are presently there. Trying to scare him that he's going to be there for years and years, not just a couple of years. And then they bolstered that by saying, you know how many people we got left to try? Over a dozen. You'll be here the whole time. And then following the above coercive actions by Judge Glanville in conjunction with one or more attorneys from the Fulton County DA's office, Copeland stated that in an ex parte meeting that he would testify. When they twisted his arm that hard, he said, okay. And then Glanville presented Copeland with a printout of the perjury statute saying, just so you know, if you lie to us, what could happen to you. And then Hilton said that if Cole testified, he told them, hey, I'm still going to lie. Show me whatever printouts you want. I don't care. I'm going to lie. I'm going to lie like a rug. And then, as far as we know, Copeland's statement that he would lie, ADA Hilton said she would go ahead, lie. We're not going to prosecute you. You can lie. That's fine. We won't prosecute you. And he's like, oh, cool. Well, in that case, if I can lie, you're not going to prosecute me. I'm going to claim that I killed Donovan Thomas, one of the people who the defendants are accused of murdering. He said, whoa, I'm going to let you lie. But if you claim that you killed him, in that case, I'm going to prosecute you for that perjury. All of this is so completely insane, if true, completely insane. And then when we threw this up to the judge, Chief Judge Glanville denied that the one or more events above related to him were accurate. I don't remember that. I don't remember him actually denying any of it, to be honest with you. So there you go. That's his motion. Looks pretty strong. Not going to kid you. I think this judge is out. I think he's out. Matt Skinner hitting me with 10. Good Lawgic memberships. God bless you, Matt. God bless you. I got to find that now. I got to find the 10. Who do you bring in here? This is going to be work. It's going to be tricky. It's going to be tricky. Let me see if I can pull this up. We're going to see. Maybe I'll get it. Maybe. Maybe. Let's see what we got in here. Let's see what we got in here. Maybe, possibly. It sucks. Well, those of you who were brought into the following courtesy of Matt Skinner, who I can't bring up, who brought in here. I apologize to you, Matt, for that. But I'm going to give you another horn. Welcome to Following the Following is not at all. It's not the type of cult that your father would have joined. No. No, because it's not at all a cult. In the 60s, they had all these crazy types of cults. People wore the hippie clothing. There's no lays here, okay? There's no poi. There's none of the hippies with the flowing gowns, the very unflattering type of floral prints. It's not at all a cult type of cult. So, yeah. But welcome to the following. Those who were brought in, please express your gratitude to Matt Skinner for his very generous work on your behalf. There's no immunity from street justice. Yeah, that's why he's like, I'll lie like a rug. I don't care. I'll say, I am not going back on the street after testifying. I ain't no rat. Is this motion different from him asking for the same in court today and the attorney asked for release to go to appeal? It was denied. It is a little bit different. It spells out all the facts in a nice, concise way. It helps with the appeal. Also, it's also arguing that he cannot decide this motion. So in that sense, it has significant distinction. What's the count, Joey? The count? Wait, you want to know the count? When you're asking the count like right now? The count? Mm-hmm. I'm going to look at the count. Yeah, it went up by like 9 people. If that's what you're wondering. I don't know if you mean paid members or not, but there you go. Start at 726, up to 735. Supposed to do this? Am I supposed to do this? Is this what people want me to do? The little guy running along there. See, hit the subscribe. That applies to people who are over in Rumble also. It's not, a lot of people in Rumble think, "Oh, I get a pass. I don't have to sign up." No, I need you to sign up too. I need you to sign up as well. I always thought that the awkward smile is the funniest thing in the world. Not an easy question, but how do you feel about tort reform? Can we please get rid of Latin? 3 strikes and you're out for judges. Tort reform, I would tell you, it depends on the nature of tort reform. I kind of like the idea of losers pay. That I kind of like. Losers pay. Losers pay attorney fees. We'll never get that, though. The Bar Association is way too strong. Way too strong. But, I mean, tort reform just means changing our tort laws. So you have to be a little bit more specific as to which way, what type of tort reform you're looking for. But, yeah, that type of tort reform, I would say to that. I think that's the funniest thing. I can make myself laugh in ways that few can. All right. Prosecutor Love filed a crazy motion today. Check it out. Really? I gotta find another motion. Another motion chip Chip wants me to find another motion. YSL prosecutor. I'm not seeing it. I'm not seeing this. It's on his Twitter. All right, I'll check Holloway's Twitter. What is this?
Call my name as what can I say? I'm with the experience of a black woman who is attacked and over sexualized.
Sexualized.
See, I'm so tired of hearing these idiots call my name as Fanny in a way to attempt to humiliate me. Because
like it's spelled?
Silly schoolboys, the name reminds them of a woman's rear, of her behind. Can I take my time?
Oh my God. This woman, every time she gets up and speaks, every time she makes it worse. Trying to find.
Consistent with that, pursuant to my attention, Mr. Weinstein, you have filed a motion to recuse me. You have filed an affidavit consistent with that, pursuant to...
I haven't seen this yet.
Uniform Superior Court Rule, I believe 25.2. The court's had an opportunity to read your motion. I've also had an opportunity to take a look at, because this issue comes up a fair bit, Baptiste versus the state. I invite you to take a look at that, and that's from our Court of Appeals, 229 Georgia Appeals 691. Basically, you can't file a motion to recuse for ruling that a trial judge makes, okay? And that's what you're doing in this particular situation.
No.
You're saying you don't like what
it's not a ruling that you make. It's not for a ruling that you make. What are you talking about? It's got nothing to do with a ruling. It has to do with your freaking meeting that was completely inappropriate.
Ruled upon, you're alleging some facts in an affidavit that support that decision. Because if that were the case, then no trial judge would be able to sit through a trial and give adverse rulings. So
wrong, lies. That's crap.
For the reasons set forth in Baptiste and other cases, I'm going to deny your motion to recuse on its face. Okay.
Wow. This guy digs himself a hole any further. He's gonna burn up from hitting the center of the earth, because it's not true. You wouldn't make it all the way to China. But what you heard as a kid is just not true. He ain't gonna make it to China. He's just gonna burn up. He's gonna flame out. He's gonna flame out like Perez Hilton if he digs any further. Oh my God. That's crazy. I'll look for this in a moment, okay? Oh, and also, welcome to the following. Corey, nice. He's going to flame out. This is crazy. I mean, I don't need to pull up this Baptiste case, because Baptiste case, the way he reads Baptiste, has nothing to do with this. Nothing to do with this at all, because Baptiste is specifically saying, if you don't like a decision on emotion, it's not a decision on emotion. It's about what the heck you did. Oh, my God. Speaking of oh, my gods. I'm just going to drop this. I'm going to drop this for Corey. Gifting 50 memberships. Oh, my God. I'm going to come back to this. We're going to come back to this afterwards. I need to save this space, because I'm going to have to go through all 50 people. I'm going to have to go through all 50 people. I'm going to go through them. I'm going to count off all 50 of them. You're going to be, if you can each in the interim while I'm playing the rest of this. If you can just acknowledge and give thanks to Corey for, my God. Wow. That's crazy. Welcome to the following, Corey. Thank you, my brother. I assume Corey is a man. I guess it could be either way. Well, Corey, whoever you are, God bless you. Thank you so very, very much.
Okay.
Your Honor, may I just address what you said? I disagree with your characterization that I filed a motion as a result of any ruling.
No. Well, you did in your affidavit. I'm taking in your affidavit as face value. Okay. All right. I'm not contesting where you got the information from, at least not yet.
Yes.
But I'm just saying that because it also encompasses that I made a rule.
He's so out of control. He is so out of control. Oh my God. So out of control. Wow.
And as a result of that, if I make a ruling and you don't like it, then every litigant will say, I want to recuse you, Judge.
It's not that I don't like your ruling as to the oral motion that was made. It's I don't like what the heck you did. What you did here mandates recusal. He's so out of his mind.
Smith or Judge Glanville or Judge whoever. Okay, so part and parcel of it is that's why I'm making my ruling in this particular case. Remember, bias. I've got to do something extrajudicial, and you're in your particular Like I would have to say something about you or your clients or anything like that, which I would
No,
never do.
no, you would have to twist a witness's arm into testifying, even if he's going to perjure himself. And with the DA saying we're not going to commit perjury, we're not going to charge you for perjury. And then when he says I'm going to testify that I killed someone, that they are going to testify for that. Well, what if he testifies that none of them did anything?
Because I'm a steward of this particular process. So I understand what your objection is.
What if he testifies wrongly that they did commit a murder? She's not going to be prosecuting them for that. That's ridiculous. This is insane.
Well, what your statement is in terms of your motion to recuse, I'm going to deny it.
And I believe, Your Honor, that under Rule 25.3, that you have to cease acting right now.
No, I don't.
And that you can, if I can just finish, and then I promise, if I can just finish this. I believe you have to cease acting. I believe that under 25.3, you have to look at the timeliness of the motion, and you have to look at the sufficiency of the affidavit. I do not believe that you are permitted to just simply deny without taking those steps.
Is that it?
Yes, it is, Your Honor.
Okay. All right. So noted.
Are you denying at this point?
I'm still denying your motion, okay?
Would you grant a certificate of immediate review?
No, sir.
Because
No, sir.
if you grant that certificate,
Certificate of immediate review enables the appellate court to look at it immediately without them going further in the trial. So he's like, okay, are you going to let the appellate court look at this?
you're always talking about how the appellate court.
No, because if I grant the certificate, it stops the case, okay?
I don't agree with
And
that.
I'm not going to do
I
that.
don't believe it stops the case.
I'm not going to do that.
And if you
You can appeal it at the end of the case. If I'm wrong, I'm wrong. Hey, I'll live by it.
No, yeah, I don't know that he's going to live by this so well. Certainly, no one should mistake that as me making a threat. I'm definitely not making a threat. I'm simply saying I don't think he's going to be happy with the results of how this whole thing plays out. I think he's going to be really, really upset with the way this whole thing plays out. He looks like a clown. If he walked into this courtroom with, painted his whole face with the big lips and the huge red nose and the floppy shoes, he wouldn't look any more clown than he looks right now.
The case right now, Your Honor. If you grant.
Sir, I'd be real careful about what you're pleading at this point in time and what you're stating to the court. As a matter of professional responsibility, remember, we haven't nugged out all of the issues involved in that affidavit. And I would be very careful if I were you, because you have some professional responsibility obligations individually and to this court.
So now he's threatening him.
So I would just leave it at that respectfully. I don't want to get into an argument with you about that. But
it seems like instead of getting into an argument, I'm telling you shut up.
At this point.
I understand, Your Honor, and I believe that the certificate of immediate review would be in the interest of the court.
I'm not going to do that.
Would you make factual findings regarding?
I am not at this point in time going to I've denied the motion. Okay.
I believe that's an error, Your Honor.
All right. Okay. Thank you, sir.
Thank you.
All right. Can we call Mr. Copeland now, please?
Wow. This case, every time I think it can't get any crazier, unbelievable.
My attention, Mr. Weinstein,
the test of whether an objective, disinterested observer informed of the relevant facts would have significant doubt whether the judge was impartial. And you don't show actual bias for the disqualification. This is craziness. Unbelievable. I'm still trying to find this motion. Brian Steele looking for a supersedious bond on his criminal contempt pursuant to Court of Appeals Rule 40B in support of his emergency motion. It's going to Supreme Court, not the appellate court. Interesting. Wow. This case is fun. This case has become fun. Let me hit up on the let me do real quick before I look at that any further. I didn't expect to spend this long on this, but this is just too much fun. Wow. Okay. Following people gifted memberships courtesy of Corey Boatwright. You ready? Here's a list. I'm going to give you another one of these. This is for Corey Boatwright, gifted 50. I guess you'll all count off and see if I missed any. I'm not going to be counting, but I'm hoping that I get them all. All right, here we go. Who just became a member of the following, courtesy of Corey Boatwright? Well, you got Cat Mama, Patrick Allen, David, Let My People Go, Jeff King, Marlo, Crescent Fresh, WW, David, J.I., Fiery Red Podcast, Kim Smith, Anthony, K. Sarah, Victor Man 777, Mr. Remakes, Robert Pennington, Space Baby, Sherry Ward, Awakening Wonder, Live Laugh Bark, Sadie, Wisconsinite, Dana Babe, Harlan. Oh no, it jumped on me. No, now I gotta go back. Oh, it jumped on me. Why did it jump on me? Damn you, YouTube. Damn you to hell. It jumped on me. I can't even go up. I can only see Angela Brewer, Pam Graham, Nancy Lorenz, King Ginger 333, Rabbit Stick, Denise Scott, S.A. Alba, Janella Rella, Ron A, Zena B, Night Watchman, Jason A, Catherine, Rocky, Renee Barnes, Randy C, David Noble, Garrett Pace, Stephanie, Netcat Media, all of them gifted memberships, as well as probably 24 others that I can't even get to anymore. Well, if you're a new member of the following, I hope first and foremost that you thank Corey Boatwright for that very generous gift. And secondly, please bear in mind that the following is not at all a type of cult. I am not the leader of the following. Say it with me. Joe is not the leader of the following. We say it twice so that we know it's cemented. Everyone understands. Joe is not the leader of the following. I'm just a host. Wow. Thank you again, Corey. 100K. So close, Joe. I sub to you on YouTube, Rumble, and Locals. Do you want to give blood? Give blood. Just cut me. I ain't going to cut you, kid. Love was complaining about objections to her leading questions on her witnesses, according to Thugger Daily. Okay, let me see. I was supposedly tagged. Let me see when I was tagged here. I'm supposed to check that out. Let's see what that was. Can you all see that? I don't know if you can. That's not working. I should have just made this about Glanville today. Who knew there was so much craziness here? Who knew? State of Georgia buying through Fannie T. Willis. Sorry for sexualizing her that way. District Attorney for the Atlanta Judicial Circuit and the undersigned Chief Deputy District Attorney Adrian Love hereby moves this honorable court to overrule defendant's improper objections premised on the assertion the state is asking a leading question when the question propounded does not suggest the answer desired, but instead refers the witness to the topic to be answered. Recognized question: does name Judge Fennell ring a bell? Posed by the state after witness cannot recall a name. Was not a leading question. Of course it is. Stating the fact that the question refers the witness to the topic to be answered does not make it a leading question. The questions may legitimately suggest the witness the topic of the answer. Like it might suggest the answer to you. Does it seem likely that this is the person who shot them? Does that give you does that ring a bell? Are you out of your mind? Wow. She's crazy. They're crazy. They're such bad attorneys. They are so bad. They are so bad at their job. You stink. Learn to ask a question. Questions may legitimately suggest the witness topic of the answer. It's not topic. You're suggesting the answer. That's the problem. That's what makes it leading. Since the start of this trial, counsel friends have represented to this honorable court that questions posed by the state refer the witness to the topic to be answered. For instance, do you see Dolly in that picture? That is a leading question. Or is Dolly wearing a white shirt? Are impermissible leading questions. Counsel for the defense have repeatedly objected to such questions posed by the states, and in many instances, the objections have been sustained by this honorable court. It's not our fault. We don't know how to ask a proper question. You need to cut us some slack here, Judge. We don't know how to ask a proper question. Please don't make us ask proper questions. What do you think? We're lawyers here or something? How are we supposed to know how to ask a question? Wow. As officers of the court who suck at their jobs and don't know how to ask a proper question, the state has a duty to present to the court applicable case law that governs contested matters that may arise through this trial. Accordingly, the state respectfully moves the court in limine to overrule all objections premised upon the notion that the state sucks at asking questions and asks leading questions. When a question propounded does not suggest an answer, but simply suggests the witness topic, the topic of answer and calls for a yes or no answer. That's exactly what leading is. Trying to cite Burden v. State. Really? That's what it is, Burden? I'm just probably got that wrong. Holding the trial court did not err in overruling defendant's objection to the question regarding did not err doesn't mean that's proper. It means was the man a victim because it was not a leading question as it did not suggest a desired answer. Instead, simply called for a yes or no response from the victim. This is literally, we suck at our job. Please cut us some slack. That's what that motion is. Your Honor, we're really terrible at this. We don't really know how to ask questions. What do you want from? What am I supposed to do? I don't know how to ask questions. They're going to have to be leading. If you're going to cut out leading, questions, you can leave us nothing in the arsenal. What are we supposed to do? Unbelievable. Thank you for sharing that, Chip. Jackals, new member. You've been here before. You were here as IWD. I know you. Isn't this judge saying I'm going to cost your client more money, a lot more money? He's saying all sorts of things that sound completely impermissible, Matt. I don't understand I don't know what he's thinking at this point. I don't think he is. I think he's just reacting emotionally. This is like someone just injected him with some terrible batch of hormone therapy, and he's really struggling to keep it contained when he's being presented with issues regarding the logic of how he's approaching these things. Watch part when Ashley Merchant comes in. I covered what she came in again. She came back. Did she come back? Did she really come back again? Yeah, hit the like button. That was the other day. I covered her coming in. All right, this I got. Got this. I think I'm wrapping up here on this. Yeah. We're so bad at our job. I don't know what we're doing. Speaking of people who are so bad at their job, switching gears here a little bit. This is what the Biden headquarters put out. Talk about people who fail, people who genuinely fail. That's what I should have called this stream. People who fail. No, Joe, not getting into heart-shaped bubble bath jacuzzi with 20 other people on the phone. Yeah, I'm not asking you. I wouldn't put you in that position. So speaking of people who fail, check out this. This is from Biden HQ. Look what they put out 4 years ago today. A feeble and pathetic Trump had to be guided by a handler as he could barely walk down a ramp. It's not a ramp. It's a moving ramp. It's what they put out. Look at the ramp and you'll see that even when he's not moving his steps, he's moving forward because it's a moving ramp that they put him on. That he's walking a downward sloping moving ramp. Steps on it, he's moving and his feet aren't moving. And they're making it like this is some own. This is an own. That's their own. Look how this blows up in their face. That's where the Biden headquarters wants to go? That's where you want to go? Okay. If that's what you think is going to work for you, here we go. Oh, no. These are the responses to their tweet. That's not good. Well, there goes our president. Oh, no. Oh, there's beating again. Again. Oh, no. There's another one. Just when you think you beat all the stairs, there's another one there.
Has allocated to invest in police departments and training of police officers. It appears as though the president did have a slight trip there as he's boarding.
Surprise, surprise. I made that one. Phew. Fun times in Biden headquarters. Fun times at Biden headquarters. Oh, here you go. I don't even believe this is President Biden here. It doesn't even look like him anymore. This doesn't even look. It doesn't even look like it. It looks like some Frankenstein version of him. What's going on? Where's he? Ice cream! I want ice cream. Joe! Oh, is that what's happening here? He looks so cool. Oh, he looks so cool. I really love this one. I hear ice cream truck. Look at that woman over here. She's like, where's he going? Oh, poor Joey. Any more? Oh, here we go.
Yep, over there where I just pointed. You got to go down the stairs. Don't trip.
Kawawa.
Who the fuck are you saluting? Oh, please bust your ass.
Hey, see, I'm not a big fan of the whole fart insertions.
Mental filth.
Compared to Biden? I'm sorry. Wait for it. Watch.
Mental filth. My physical as well as my mental fitness.
have a feeling YouTube's not going to like this song, whatever it is. And yet, without music, it loses so much.
End of quote. Repeat the line.
End of quote. Repeat the line. I forgot about the repeat the line. End of quote. Repeat the line.
Over $1,300 million. More than half of the women in my administration are women.
Yeah, it's like I said, I'm not a big fan of the whole fart noise thing. To me, that's like I can do better than that. What I can't do better than though, Matt Skinner, 20 good Lawgic memberships. Who just came in? This one I'm gonna get. Matt Skinner gifted. Wrestlertown, Riley Leifson, the one-headed man, Vance Olshev, Karen E, Joe Vagan, Philip Chagoyan, Sandy, Drop Barracuda, Bria, Darren Amstutz, and you get a membership. Unbelievable. Pug Genie, Rob Allen Jr., Cindy Wyatt, Hey, Ms. Mo, No Jabsky, Kelly R, Marvin Gaiman, Mullen Labe, all of them gifted, courtesy of Matt Skinner. Matt wants me to remind you that Joe is not the leader of the following. Joe is just the host. I'm not the leader of the following. Say it with me twice. Joe is not the leader of the following. Crystal clear. Make sure it's crystal clear that there's no confusion. The following is not at all a cult type of cult. Not even in the slightest. Not mandatory that you get digger tools or track suits. There's no laurel wreaths being put on people's heads. There's no new age music. It's just not at all a cult type of cult. You heard it here first. All right. Well, welcome to the following, all of you. Please remember to express your gratitude to Matt Skinner, and I appreciate you. Thank you, my brother. Thank you so much. Hit you up again. All right. Let's get into speaking of ridiculous positions like the Biden headquarters. In case you missed it, Hunter Biden was convicted, found guilty on all 3 charges, and this is the idiocy that we're getting from the likes of CNN. This is the idiocy. Hunter Biden conviction shatters Trump's persecution narrative. Really? Does it? Does it though? Does it really? An unprecedented 2 weeks of legal drama that yielded historic convictions of former president and sitting president's son have also produced a clear political takeaway. Crystal clear political. The survival of the rule of law in America and untainted justice may depend on the choice voters make in November. What? The country's divergent possible paths under President Joe Biden and presumptive GOP nominee Donald Trump were highlighted. Isn't it presumptive? DNC candidate Joe Biden? The way both men, their families, and their political operations reacted to the twin trials and verdicts. Biden made no effort to interfere in the prosecution of his son Hunter because he knows that he'll be able to issue a pardon to him 10 seconds after the election is over, with either his executive authority or with the media megaphones. Really? With the media megaphones, he said it's not his laptop. Said that over and over again. Not his laptop, which was a flat out lie. How do we know that? Well, the trial, the DOJ introduced the laptop. That Joe Biden lied to the public about before the last election, saying it's not his laptop. Apparently, court of law now found it is his laptop. He allowed his own Justice Department to secure a guilty verdict. No. that could result in jail time for the recovering addict and hurt his own 2024 campaign. Okay, let's slow down here for a second. First, the DOJ came in and said, we're going to offer you a sweetheart deal. That was rejected by a judge saying that's too much of a sweetheart deal. And you're putting me in a position where you can't even go after him and prosecute him for crimes without coming to me first. And that's a violation of separation of powers. So you bent over so far backward here trying to protect Joe Biden's son that you put me in a position that I'm not allowed to be in. So you got to rework this whole deal. And when this came to the light of the public, everyone's like, what the hell is this DOJ doing here? What they also did was they allowed the statute of limitations to lapse with respect to various claims that they should have had for his tax evasion. Let it lapse. You didn't see that. You didn't see any statute of limitations lapsing against Donald Trump. Quite the contrary, what you saw is they would change the law and say statute of limitations that are gone with respect to E. Jean Carroll. Also, we're just going to resurrect that now for 1 year, specifically so that you can go after Donald Trump for those claims that we'll be able to claim that he's been found guilty of SA. That's why that happened. They don't care about the 94 million. They want to be able to publicly lambast him and say, a jury in New York found him guilty of SA. You're going to elect someone who's committing SA. That's why that happens. Not far more than the money. I mean, yes, the money is a nice thing to try to take from his pocket. Also, the hassle and the embarrassment and all that other stuff they could try and throw out there. That's why that happens. So you're sitting here trying to profess that there's equal justice. No, with respect to Trump, they're creating brand new statute of limitations that never happened before for anyone ever in American history, that we want you to be able to go after this person. Talk about habeas corpus. Oh, they covered their tracks by saying you can go after anyone for a year. In certain degrees, it actually backfired that all of a sudden people were resurrecting claims and the court didn't know what the hell to do with it. But they changed the law of statute of limitations in order to try going after Trump, as opposed to with Hunter, they allowed the statute of limitations to lapse so that they could not go after him. They also didn't charge him with FARA, Fair Administration, the Foreign Agent Registration Act. FARA, which is that he had a duty to report that he's working for foreign companies. Things like Ukraine and his work for Burisma. Why didn't they charge him with that? Why did they only charge him on this gun possession issue? I'll tell you why that happened. The reason that happened was because those are charges which are in no way relatable to Joe Biden. Quite the contrary, they make Joe Biden look like a loving father who's trying to figure out how to deal with his son who has this terrible addiction to drug. So it's a terrible, terrible thing. They paint Joe Biden as being some loving father. This is just a story. This is a story of a man who loves his son. As opposed to FARA, which would necessarily implicate, well, what did you do while working as a foreign agent? And how did you accomplish that? And who were you dealing with? And why were they paying you millions of dollars? And what happened with respect to these phone calls that your father is calling into these board meetings? All that stuff, which would have been very ugly and very bad PR, all that sweep under the rug. And here comes along CNN saying, well, I got more sweeping to do. We'll do more sweeping for you. See, this shows equal justice. Equal justice. No, this is a display of how unequal the justice is, how gross and disgusting this administration is, how gross and disgusting our institutions are, where those institutions are perversions of justice by our judiciary or by the prosecuting agents, for the DA's office in New York, DA's office in Fulton County, Georgia, or the DOJ. The weaponization of the DOJ in trying to create some new office for Jack Smith, even though he's not really legally empowered to do anything, but acting with the authority of the United States government. To the institutions of our legacy media, like these jackasses over here trying to pretend that this displays equal justice when it displays unequal justice. Literally, black is white, white is black, and blue is purple, and green green is a tomato that should be fried. Actually, that I think is something. But yes, it's astonishing. It's astonishing how they could just try and twist and pervert everything. You are displaying how gross everything is in a Biden world. You CNN, you're doing it more than anyone. That's their cope. Their cope is, oh, you see, this shows how everything is just and equal and fair and fair. He also said he won't pardon his son. Well, he also said it wasn't his laptop, so I don't know if we can take his word for it with respect to anything having to do with this case. Probably said he won't pardon his son because what do you mean? Well, what he'll explain is I had already pardoned. I had already issued that pardon. In his first reaction to the verdict, Hunter Biden didn't attack the judge prosecutor, simply saying he was grateful for the love and support of his family and blessed to be clean again. Yeah, he's very clean. He's crystal clean. He's crystal meth clean. The Biden comportment contrasted with Trump's reaction to his own trial and conviction, which was a joke and insane. See, the thing is here, he had no defense because he clearly had done what he was charged with. Now, frankly, I happen to be of the opinion that Hunter Biden should not have been charged with these charges. I think that these charges and this statute violates the Second Amendment. And I want to go and be crystal clear about this. Even though it's Hunter Biden, even though Hunter Biden is a slimy dirtball, really messed up individual who's probably a victim of having crappy parents, it's probably part of it. Terrible parents who had no idea how to raise a child and just suck at parenting the way they suck at everything else that they do. And they basically never taught him discipline and pampered him and gave and spoiled him and let him do whatever he wanted and let him live the life of some jackass who's going to produce nothing other than illegitimate children. So that you could certainly look to his parents as far as their terribleness in that regard. But I'll share with you that he this entire prosecution was something that he couldn't get around. And even though he's such a terrible clown, I don't think he should be prosecuted because I think under Bruin, if you look at New York Rifle Association versus Bruin, Supreme Court decision from a couple of years ago. It was last year? Couple years ago. I have to check the date. I remember it's 23, 22. Drawing a blank now. I think 23. In 2023 says that Second Amendment rights have to be read in the context of their history in America and how they're regarded in history, historically in America. And historically, banning the right of a drug addict to get access to weapons is not something that the founders ever seemed to lay into the Second Amendment. It's a relatively new thing. And I think that, and what's interesting is that he's filing a motion to appeal. And it'd be amazing. I really think that it would be amazing if, in fact, he succeeds. I wish him all the blessing in the world that he should overturn these convictions on appeal. Because, frankly, this law is unconstitutional. If you have a drug problem, it has nothing to do with your right to get to bear arms. Nothing at all to do with that. Now, yeah, if someone, you still have to deal with them responsibly, same as anyone else would. But the assumption that they should not have the right to bear arms is that's not consistent with the historical interpretations of the Second Amendment. So we should all hope that U.S. v. Biden sets successful precedent that the Second Amendment extends to drug addicts, so that the Biden legacy will be broadening our Second Amendment rights. Amen. Please let that be. That would be amazing. Let that be their legacy. Not the leaders. No! I don't even know who you're talking about now. You passive. Vince Olshov would like to know why the gun dumper hasn't been charged. I don't know. It's a good question. I don't have an answer to that. Because they can charge whoever the hell they want to charge. And they wanted CNN to put out an article like this. So you want to see more coping? More coping? And they can say the same thing. Exactly. You drink caffeine. Oh, you can't possess a firearm. You kidding me? He's on Red Bull. You're going to let that Red Bull drinker handle a pistol? Are you out of your minds? Stupid. So ABC News also saying, don't worry. The Hunter Biden's guilty verdict probably won't affect the 2024 election. Such cope. Such cope. 2024 presidential election is starting to feel more like a season of Law and Order. On Tuesday, now 2 weeks after Trump was convicted of fraud. Let's remind you about Trump. Joe Biden's 54-year-old son, Hunter, convicted of illegally purchasing a firearm by not disclosing his drug use on a federal form. While Trump's conviction appears to have cost him a small amount of support of early post-verdict polling. Really? Because it seemed to get him $1 billion. That's what they raised, supposedly. $1 billion. That really hurt him. It killed him. Crushed him. Such cope. It's not going to have the same effect on Joe. No, this conviction is not going to hurt Joe. First of all, a lot more Americans paying attention to Trump's trial than Biden. So don't worry. No one was really watching this. Oh, my God. Plus, because the fact that Trump is running for president and Biden, that is Hunter Biden, isn't. Well, it's not sure that Joe is actually running for president either. True, a Marquette University law school poll from May 6th to 15 found that 45% likely voters thought Joe Biden did something illegal related to his son's business dealings. An additional 25% thought he did something wrong but not illegal. So far, no evidence. There's no evidence. I don't know what that means. It's like they're bending over backwards to find new definitions of the word evidence in order to try and put the modifier no in front of it, because there's tons of evidence. 10% for the big guy. At least I won't have to give you half my earnings the way I won't make you give me half your earnings the way Pop does. No evidence. Zero evidence. I want to say something else. If you caught me on Spaces on Tuesday, there's one thing I didn't get a chance to throw out there. You know, I was arguing with Lev Parnas, who, frankly, that's slippery eel. I think that he lies every other word that he says. I seriously don't. I so many times I've caught him just flat out making stuff up. I think he lies and lies and lies. My personal opinion. I think he lies and lies and lies and lies and lies. So the news story that the left is giving, the news story that Lev Parnas is trying to shill in his desperate attacks to, like, please don't vote for Trump, are that there's two different laptops. Two different laptops. That's what he said. See, it's true that the laptop that the DOJ presented, that was real, but the one Rudy Giuliani presented, that one was not real. Interesting. Fascinating. So that one, what's been vetted according to Lev Parnas, who's been called to testify before Congress several times, according to him, it's a different laptop. Now, the MacBook store owner, he said that he mirrored the laptop. How it's different, nobody knows. Nobody can establish that. And that Rudy's is Russian disinformation. And if you're watching this live, I'm going to ask you one question. Just answer one question. When did the Russians come in there? Why would the FBI have an accurate version? And somehow this one, the second laptop, is Russian disinformation. Did they know he was going to give it to Rudy Giuliani? How did they know that? At what point did the Russians come into the store and say, oh, it's the copy, that's the one we're going to add Russian disinformation to? First one from the DOJ that's been accepted by a court of law as being valid, accurate, belonging to Hunter Biden. That one, Lev says, is totally fine. But the other one, the follow-up one from Rudy Giuliani, that one's Russian disinformation. How did the Russians get their hands on it? Why would they come into the store and start saying, this is the one we're going to change? Are you claiming that Rudy Giuliani met with the Russians and said, here, splice this up? Really? Because if he did that, I'm pretty sure he would have been charged. I'm fairly certain he would have been charged. So at what point did the Russians get their naughty little fingers on this one? Because I'll tell you something right now, that entire story is stupid. It's illogical. It makes no sense at all, because there's no moment in time where it's feasible to or reasonable to believe that the Russians would have come in there to affect this specific version of the Hunter Biden laptop. So I'll tell you right now, it's the same laptop. It's one laptop. It was mirrored. That's it. And all the stuff that we've seen, it's all legit. And why is it the DOJ is not going after it? Because it would hurt Joe Biden. We all understand this. We all know this. And you hear someone lying to you, you just sort of have to think to yourself, what is the logic in this claim that he's making here? What is the logic? Where is the logic? And anything that guy says, which just seems novel or introductory, invariably crumbles under the slightest scrutiny of logic. What else I got for you? I haven't checked over here. Let me peek over, make sure I haven't missed anything. I did. Denise Ann says, I agree, Joe. All gun laws are unconstitutional and should not have been charged. Sad day for 2A. I think it's going to be overturned. Don't worry, Denise. It's going to be overturned. Let me check over on locals. Make sure I missed nothing. There's been a whole bunch going on locals. Neurodivergent says, Joe, you need a mob in Rumble for the spam. I like Duck Hunt if you want to mod me. Okay. One of these days, I'll figure out how to get my card to work on Rumble so I can send a Rumble rant. Oh, well. No one can figure out Rumble rants. All drugs should be legal, Joe. I'm sort of torn about that whole thing. I'm sort of torn about that. All right. Finally, what I want to cover tonight, Alex Jones. Let's talk about Alex Jones. We're going to do a little bit of an analysis here. This is going to be less opinion. I'm going to try and give you more law and understanding how bankruptcy court works and what's happening here with respect to an application that commenced today from the families of Sandy Hook and their position here. First, I got to jack my chair up. It's very annoying. Annoying thing I have in my chair. I've been in an argument with Lady Lawgic about this. She's sleeping. She can't hear me. I was like, I really need a new chair. It keeps sinking. And I hate it. I'm like, all of a sudden, I'm like lower than potentially criminal Sean. It's like, what the heck is happening? Hey guys, let me tell you about the law. The Alex Jones case. It doesn't work. So, where was I at? Yeah. Okay. The proper standard for the second 2A argument would be an honest answer and denial on that basis. That's what Heller and others have done. You still could say that the statute is unconstitutional. In which case, it's like relatively a harmless lie. I think he has standing. It's an interesting question you're implicitly asking there. All right, let's check out what's going on with Alex Jones. Let's get to this. Sandy Hook families want to seize Alex Jones' social media accounts. Why is it doing this? I'm not going to have this thing. I don't like the banner on top. It's very annoying. All right. Families of Sandy Hook massacre victims want to seize Alex Jones' social media accounts in his bankruptcy, saying that the conspiracy theorist's frequent posts to fans are a key part of the InfoWars business being liquidated to pay Jones' debts. So they want to use the asset of his social media accounts. Jones, who filed for bankruptcy protection 17 months ago, has given up on trying to reach a settlement that would reduce the $1.5 billion that he owes the relatives of 20 students and 6 staff members killed in the 2012 mass shooting at Sandy Hook Elementary School in Newton, Connecticut. By the way, he made them a very generous offer, which I think that their attorneys are going to find was very foolish to turn down. Where he was giving them like $1 million a year or something like that. It was just like, it was insane how they turned it down. Because executing judgments is very tough, even when you have what seems like a big pocket like Alex Jones. Jones and the Sandy Hook families now agree that Jones' assets should be liquidated in bankruptcy. The families on Wednesday asked the U.S. bankruptcy judge in Houston, Texas, to additionally take control of Jones' X.com account and prevent Jones from using it to promote new business ventures. Okay. Sandy Hook families asked Judge to make clear that the Jones @RealAlexJones account on X.com, formerly known as Twitter, will be among the assets turned over to a court-appointed trustee in charge of liquidating Jones' assets. Jones' X account, which has 2.3 million followers, is, quote, no different than a customer list of any other liquidating business, the Sandy Hook families argue. That's not the best argument they can make. The best argument they can make is that it has... is that it has value. It can be sold. They argue that Jones has used social media accounts to push down the value of InfoWars by diverting sales from the site of the father's drjonesnaturals.com, which sells health supplements and other products. Jones' attorney, Vicky Driver, said on Thursday that Sandy Hook family's request was procedurally improper, and Jones would oppose it at the appropriate time. The Connecticut plaintiffs have never wanted money from Jones but to silence him, and that's how it comes across. You say, hey, we don't want him to be able to speak on Twitter to his 2.3 million followers. It comes across like you're trying to just step all over his First Amendment rights. Jones was banned from the platform for nearly 5 years, but his account was reinstated in December after a user poll conducted by X.com owner Elon Musk. U.S. bankruptcy judge is scheduled to hear the family's demand at a Friday court hearing in Houston. The judge expects to convert Alex Jones' bankruptcy case from Chapter 11 into a Chapter 7 liquidation, which would allow a court-appointed trustee to take and sell Jones' assets. Jones claimed that for years that Sandy Hook killings were staged. Okay, fine. He says he has less than $12 million in assets. Let's talk about this asset for a moment here. And then we're going to look at the viability of selling this asset. Normally, when you're talking about Chapter 7, you're liquidating assets. So you say, okay, what assets do you have that we can try and sell and market? Use that money toward satisfying the debt that's outstanding. And the question is a Twitter account, is that an asset you can sell? And that's really a key question here. My first thought is no. And then I thought about it more and I said, well, maybe yes. I know of people who sold their YouTube accounts, some for like 5,000, whatever, 10,000. You said sell them for 100,000. And the bigger the account is, the more you could sell it for. So trying to look at this fairly, if you're sitting here if I was sitting here as a judge, trying to decide whether or not this account can be liquidated, my first question would be, well, is it transferable? Can you sell it? And what type of impact are you talking about on the debtor? And what type of benefit is there to the creditor? Right? So you're sort of trying to deal with what are we doing with this asset? Is this something that can turn into cash to help satisfy the judgment? Because that's your role as the judge. You're supposed to try and figure out what assets there are. And if that's an asset that is transferable, well then, irrespective of his First Amendment rights, he can always go on Twitter, start a new account, and talk to people that way. But his existing account, which has 2.3 million followers, if someone's willing to pay for it, the first thought you would have is, well, why can't you force him to sell it? It doesn't restrict him from being able to talk on X. He can start a new account. This account would be, in theory, transferred over to a different person. They would pay X number of dollars, and we'll talk about how much money that potentially could be. X number of dollars, and this way they have an account which now has access to 2.3 million people. If you're some big company and you want to promote products, that especially if you have products that you think these listeners, these followers may be interested in, you can understand how that can be worth a lot of money to you. That all of a sudden you can keep tweeting out there promotions where all of a sudden Alex Jones, let's say he's forced to sell it off, and Tropicana comes in there and they start basically, or some gaming company or whatever, some company comes out there and says, hey, I'm going to now use this account, which has 2.3 million followers, and just start pimping out products that I'm hoping these people will be interested in. So you can understand how that does, in theory, have value. Let's take a look at how much value that potentially could have. That's not it. Where's the first thing I found? See, I found something here that said that the value of a Twitter account is somewhere between $1.50 and $4 per follower. Taking that at its most conservative, $1.50 for 2.3 million followers, you're already talking about $3.5 to $4 million just from selling that account. That's a lot of money. That's a lot of money. I missed your $5 super chat. Did I? I apologize for that drop there, Kuda. Where are you? Did I miss that? I apologize. How did that happen? I actually remember seeing something about Karen Reed. Maybe I do think I think you're right. I think I missed it. I also missed Barbara Zaleski becoming a new member. I missed a bunch. Watch some of Copeland testimony. I think it helped. I don't think it helps the DA much. Guy cannot remember anything. He said he lies to get out of trouble. Oh. I missed this also. How did I miss all of these? Maybe next we'll learn Fannie Willis having an affair with one of the young thug. That's funny, Joe. That's really funny. Be a gangsta and subscribe. Watch. I think I jumped out after I saw this one. All lock arms repeat. We are not in a cult. Very much not in a cult. Very, very much not in a cult. Not in a cult at all. I did miss a whole bunch. I'm glad you called this my attention, Backroom. Fun times in Karen retrial. The term balloon knot was explained to among other fun things. Really? Really? I don't know what that is. I do not know what that is. What are these things? Did you get your... I didn't get cheesecake. No. I mean, my wife made cheesecake. And she makes delicious cheesecake. It's not cakes. Cakes is what you're talking about. K-Y-X. But yeah. Anyhow, getting back, I apologize for missing that earlier, Barracuda. I'm glad you called that to my attention because I missed a whole bunch. Okay, so getting back to this Alex Jones thing, if we can jump back in on that. So apparently you can sell it, from what I've seen, from anywhere between $1.50 to $4 per account. In fact, I'll show you what I found so far on this. This was Cora. How much can Twitter account sell for? The value of Twitter account can vary widely depending on several factors, such as the number of followers, engagement levels, niche or industry, quality of followers, and the overall influence of the account. In general, Twitter accounts with large following of real engaged users can be quite valuable. Some high-profile Twitter accounts owned by celebrities, influencers, or brands have been known to sell for significant amounts of money, sometimes in the tens of thousands or even hundreds of thousands of dollars. It's important to note that selling Twitter accounts is against Twitter's terms of service. And this is where we start coming to an interesting thing. Whoa, it's against the terms of service? And the platform may suspend or ban accounts involved in such transactions. Additionally, buying or selling accounts can raise legal and ethical issues, especially accounts associated with particular individual business. If you're considering buying or selling Twitter accounts, it's important to proceed with caution. And that is a huge risk, right? If you're an investor, you don't want to spend $2-3 million something and then find out that the account gets shut down. So then we have to ask ourselves a question. Can a judge sign off on selling something that's a violation of terms of service of Twitter? Is selling your account a violation of terms of service of Twitter? And that's why I'll tell you this. If I was a judge on this case, I would really be I would start with a fact hearing. I would be looking to find evidence as to, first and foremost, are you allowed to sell an account on Twitter? I think this is a fair fact question for any judge who's looking at this and trying to say, okay, look, it's my job to try and find whatever assets are viable that can be turned into cash here. The creditors are claiming that this is an asset that could be turned into cash. Is that true? Can it be turned into cash or can it not be turned to cash? And Twitter's a little confusing with respect to their terms of service. When you look at their terms of service and try pulling them up, they seem to say flat out, you cannot sell it. And then in the next breath, they say you can't squat. And that's what it seems like it's talking about here. Let me share with you what I had here. This is what I wanted here. question is, first and foremost, what do you own? When you look at what you own when you come on Twitter, so what Twitter admits that you own is you retain ownership and rights of any content you post or share. You provide with us a broad royalty-free license to make your content available to the rest of the world and let others do the same. Conversely, we provide you a license to use software provided as part of the services. It's kind of silent there. They claim that they have broad enforcement rights, but it's a little bit confusing as to when they say, when it, if you look up selling over here, do Control F and selling, you're only going to find twice that they talk about selling. They say if you want to reproduce, modify, or create derivative works, distribute, or sell, that's in the terms of service that I found when I pulled up their thing. Which this is not about selling out access to your account. So this doesn't seem to say anything about it. And when I dig a little further on this wasn't what I was looking for. I actually pulled this up here. I searched sell I downloaded it here, pulled up the term service, and looked up sell. Only twice they talk about this. Same thing. If you want to reproduce, modify, create the derivative works, distribute, sell, transfer, or otherwise use the service of common services, you must use the interfaces and instructions we provide. That doesn't seem to be restricting at all on selling your access to your account. And then I did a little more searching, and I found this. I'm just sharing with you what I found here in the limited time that I had to prepare for this show. Question being asked, is it legal to buy or sell Twitter accounts? So, is it legal to buy or sell a Twitter account? And they say it's a tricky question because there are a lot of factors involved. You hardly think it'd be a crime in any state to sell or buy an account. It's difficult to conceptualize being arrested for such a transaction, but then what happens if they shut it down? Is it against their terms of service to buy or sell an account? That's where things get hazy. Because they say, and I didn't find this that they shared. Maybe this, I'm not sure, this account, this posting came in 2022. It could be this before it became X. So I don't know that this is still there. But apparently at one point they said you can't sell usernames. You cannot buy or sell Twitter usernames. Now, with respect to that, they seem to refer to that as squatting. What do I mean by squatting? Well, Twitter doesn't like the idea that if you see someone, let's say, who's not on Twitter yet, who, let's say, who's a celebrity, that you're going to basically use that celebrity name and then try and sell that to the celebrity. That's really where they seem to have a problem. I'll come back to that in a moment. What they say is you can't engage in any form of username squatting. Anytime you register an account, it appears as though you were registered just to have it before some influential figure or entity might want it. That's squatting. And it's a way that they don't want to help you extort some celebrity so that they can get their name. Twitter determines whether or not you're squatting a username based on some historical factors. There's no question here that no one's saying that Alex Jones was squatting. And what they would do with Alex Jones, by the way, you can change the name. So whoever would take it wouldn't leave it as real Alex Jones. You can take your Twitter name and change it to something else, as long as that's not being used by anyone else at the time. So in theory, you can change it over to some game or whatever it is you wanted to change it to if you're a company that's buying his handle, and it would still have the same followers. So it seems as if my takeaway on this is this. I do think that it could be sold. In fact, there's even a company here which sells accounts called Viral Accounts. And what they do is they do exactly this. Selling a Twitter account, let viralaccounts.com take a look at your property. Our company works with over 2,000 brands who are ready to pay you the very same day upon approving the contract. Before you submit your Twitter account, please make sure it meets the following needs. You need to have 50,000 real followers, because those are notoriously easy to fake. You have a decent enough per post retweet count, and they have all those list of requirements, and basically they sell accounts for people. And Twitter doesn't seem to have a problem with them doing that. Which all of this is, and this is the Help Center's perspective on squatting, but this is not a squatting situation here. Squatting means someone who's holding the account to try and extort a celebrity. This is not a squatting situation. Outside of this context, it seems as if Twitter does not do very much to stop people from being able to resell their accounts. Now, could be there are other facts that I'm unaware of. Could be that Elon, in theory, if he wanted to, he could make it illegal to sell your account. If he wanted to help Alex out, if he came in and testified and said, "Oh no! If they sold the account, if we learn of someone selling the account, we're going to shut that thing down immediately and make it not usable," which he in theory could do. That would probably raise the hackles of a whole bunch of folks who had thoughts of selling their account. But in theory, if he was trying to save Alex Jones, and he came in there and said, "No, if Alex Jones sold his account, we would shut that account down," that would be very influential to a judge in saying, "Well, why are you forcing him to sell it?" Now, I don't know if Elon Musk has any interest in taking that position. He seems to like Alex Jones a lot, so he might take that position. But we're not going to allow someone to sell his account. And if he came in there and said we wouldn't allow that account to be used by anyone else, if we learned that it was sold, that would be, into my mind, pretty influential with the judge. So the point that I'm pointing out here is the judge is supposed to look at this with neutrality. And let's assume that the bankruptcy judge is looking at this with neutrality. I have no reason to assume otherwise. So when you see something like this, this is a potential asset. It's only a potential asset if it can be resold. Even if it is a potential asset, so that requires to my mind, I would think it requires an evidentiary hearing for a judge to come to a determination as to whether or not this actually could be sold, and then to sort of assess, okay, how much benefit are you going to get out of this? Because if you're going to end up selling this account for a total of $30,000, $50,000, that sounds like a very onerous way of punishing Alex Jones without much gain to the creditors. And perhaps there is a devaluation because of risk that it would be shut down. In which case, if I was a judge, I'd be like, I'm not going to let you interfere there. But if it's something that genuinely could turn around and garner $1 million or $2 million or something like that, I would if I was a judge and I was like, okay, look, they could sell this off and make this money. You got to explain to me why it should not be done. And if you're going to come back and say purely based on First Amendment bases, if I was a judge, I would sit there and think, well, let him start a new account. Sell off this account, start a new account. Have 100,000 people following him tomorrow and probably 500,000 people within a week. So I'm not ruling this out. I'm not ruling this out as a potential. I'm not saying it's going to work for the creditors who are looking to force it. Do I think that their agenda is nefarious and that they're ultimately just looking to shut him down? Personally, I believe yes. Yes, but it's a colorable claim. If in fact it's sellable, if it's transferable, sometimes when people are taking steps, you can have two motivations. And if one of them is justifiable, even if the real motivation is the uglier one, that doesn't mean that the justifiable reason vanishes. So if you ask me my personal opinion, why it is that they want to do this, I think they don't want him disseminating information to people. I think they want to cut him off any way they possibly can. I think they want to punish him. And I think that they're gross and disgusting. That's my personal opinion. That does not mean that they're lacking in having a colorable claim, a logical claim that even a fair judge looking at it says, look, this is an asset that they can get money from and it's going to help towards satisfaction of the judgment. They have a right to take it. I could definitely see that happening, and that's not a reflection necessarily of a judge's bias. It's a reflection of a judge saying, I'm supposed to try and maximize how much we can divest his assets, and this is a divestible asset. Now that changes completely if in fact the evidence comes in and says that this is never transferable. If it's not transferable, in that case it's really comes across more as a direct assault on his First Amendment rights rather than trying to actually get money, milk whatever money you can out of his assets. So I think it's a really interesting story. It's a really interesting question. On X, I happen to be coming close to that 50,000 threshold myself. I'm at 48.7. So anyhow, that's my story for tonight. I think we covered a lot here. My Venmo account is Good Logic. Here's my Venmo account, /Good Logic. It's in the description down below. You'll see it there. And thank you. Thank you, man. I appreciate you. To sell in terms of looks like for developers and rules for click-through sales. Yeah, I don't think it's currently against the rules of Twitter to sell your account. And when you sell the account, you literally can change everything about the account. You can change the name, so it wouldn't say Real Alex Jones. It would say Macy's. Well, it could say anything you want on it. Or it could be some individual who wants to just jump up and have 2.3 million followers. So I actually think it's a pretty good chance the judge may recognize this claim, unless Elon Musk were to come in and say, we're not going to allow anyone who takes that account over to use it. In which case the judge was basically like, okay, so I'm just here to punish him. That sounds like a direct violation of his First Amendment rights. That seems like an effort to silence his First Amendment rights. It's a really interesting question, though. It's a really, really interesting question. Anyhow, and I wouldn't be surprised if other lawyers looking at this would be like, no, this is a real violation of his First Amendment rights. And I think I could be convinced into that. But I would want to see some case law on it. If they're going to tell me that, show me some case law on that. Because he still has the ability to speak. Still has the ability to rebuild a brand. All 2.3 million can come back and hear him. It's a really interesting question. It's a really interesting philosophical and legal question. Wouldn't changing account name reduce the value? Theoretically, yeah. Theoretically, it would. But even if that were to happen, we can assume that in the first week, 500,000 people at least would probably jump ship on the account and say, I'm not following it. Why am I following this yokels? But a lot of people have apathy and don't just stop following just like that. So they don't bother doing that. And that probably would be built into what the sale price, you would think, right? Someone would be like, look, I know there's 2.3 million followers today. By the time I change the name from Real Alex Jones to something else, I know that I'm going to lose 30% of them. So the first question would be, for a judge who's looking at this, is it permissible to sell? And secondly, what is a reasonable expected value from selling it? It's a really interesting question. 2 a.m. and Budweiser is good. It's actually 3 a.m. over here. It's about to turn 3 a.m. All right, my friends, that is my show for today. I hope you enjoy yourselves. I am going to be back, God willing, Saturday night. Please follow me over goodlogic.locals.com. You want to know what the number is at right now? It's weird. It's weird. This doesn't make any sense. I don't even understand this. How is it possible I went up 13 people the entire show? And by the way, right before I opened this up, it was at 7:39. It doesn't make any sense. This makes no sense. This is YouTube. How many people were watching this thing all night? And it's like, really? 13 new people? That's it? That's it? Well, if you're here, if you can like and subscribe, I would appreciate it. I thank you all for joining me. That applies to Rumble also, by the way. I know you're all in the ghetto there. But you can follow me over tomorrow. I'm going to be on Layback Law with a whole bunch of kick-ass attorneys. So Find me there. Find me on Spaces. The way you find me all the time is at goodlogic.locals.com. That's goodlogic.locals.com. I thank you all for joining me. I look forward to seeing you all Saturday night. Till then, take care of yourselves. Do not eat bugs. Don't eat bugs. Don't eat bugs. Good night and Godspeed.